then how these cases are conducted. One part is by the lawyers, the other part is judges. So these provisions under the CPC gives certain directions for disposing of matters, especially on the appellate side. I just refer to some provisions which are relevant for consideration in the appellate side of the courts. Mainly section 2, subsection 2 defines what a decree is. A decree means the formal expression of an adjudication which conclusively determines rights of the parties with regard to all or any of the matters in controversy. So one is decree, appeal comes as 96, and then 100 CPC. This provision also makes it clear circumstances under which a plaint is rejected. If a plaint is rejected, then that is also treated as a decree. There is an appeal against that order also. Then restitution provision 144 also, it is provided as a decree. These are the two important subjects covered by section 2, subsection 2. Then you come to the main procedure, namely 96 and section 100 CPC. 96 is a very important provision because, first and foremost, when you file an appeal, a duty is cast upon each and every lawyer to study the entire paper, because law says the judge has to decide afresh, just like a suit. It's not as though he is reading the trial court judgment and give a verdict, but he has to independently consider the merits. That's the subject. So 96, the moment the client comes to you, you must see to it that he gives you all the papers. Why I am saying this is because recent past I have seen some of the cases where original records are not available with a lawyer. So when you call for those original documents which are not provided to you when you wanted to file the appeal, you may feel that there is nothing in the case. But once you get these documents and study the whole thing, you always feel there is something in it, you must make a try. You can't just say there is no case in this. So the section 96 appeals. One duty is you file the appeal with specific grounds taken on facts as well as law. Because the grounds you take now and the appeal comes up for hearing, sometime 10 years, sometime 20 years later, you may do it or somebody else may do the case also. So the grounds will give you an idea, this is the point on which somebody has prepared the appeal, so we will have to study the whole paper and do the matter. So this provision 96, the court also has to consider in deep. They can't just revisional jurisdiction, see what is the finding. Sometimes that happens in second appeals, which you will have to really feel sad when you are not able to place the facts before the court to say there is something wrong in consideration by the appellate court. You must also see the whole paper. These days the courts have no time to decide civil matters. See, early 90s, I met Justice Satyadev. I told him civil matters are not listed. In the 80s and all, 4 years cases will be pending, only 4 years. In 90s it became 8 years, 9 years pendency. Now it is 20 years pendency. There are appeals pending from 2000, 2010. The first appeals are pending even from 93, 94. There are so many cases. What is the reason? See, we have been giving letters to list the case. But sometimes unless the judge says, yes, I will hear the matter, the case is not listed. In fact, one matter, I think you are appearing other side. The problem arose because there are so many defendants. So we have to make all of them as respondents in the appeal. One after the other are dying. There are 27 applications, LR applications, and the appeal is never heard yet. The reason is the appeals are not taken up immediately. They are all put in the shelf, and it really affects the interests of parties. Sometimes the clients die. As I told you, in this case, 27 people have died, and some LRs die. Then another petition. So all these problems are faced by us. So this best method is to see that civil side, you should have a specific, just like intellectual property, they say they put a bench, separate code. Commercial division case, separate code. Why not put a specific case? And this putting 8 years case before one judge, then another 8 years case before another judge. So nothing is happening. Why not do same year case before 3 judges so that every year case is disposed of? See, 2002, 2003 matters are still pending. Sometimes you are not able to even get the client. So how to solve these problems? The best method is to, we must, as a members of this association, see that civil matters are given real weight. You can't just push this out. You must see that it is taken up. Now, this is only my grievance I am putting it. But come to the point, Section 96 deals with appeals. The appeals are filed only against decided matters, not a decree passed on consent. That all of you know. But if there is a consent decree or a compromise decree, there is some provision there where you have to go on that procedure to fight it out. Now, when the appeal is taken up by the court for hearing, what are the duties of the court? First, the court, can it, without going through the whole evidence and pleadings and the documents, decide a first appeal. But according to me, Section 96 appeals, the court is to apply its mind independently to each and every document, every case pleaded by the party, why such a case is pleaded, what is the nature of evidence written by the parties. Evidence, sometimes oral evidence only is the evidence. Sometimes the clients themselves may not know the facts because they come to court because their forefathers have left the property, they have not even indicated what is the nature of claim they have. So they find it difficult. Sometimes we, as a lawyer, will have to tell them, please trace back your title. Find out where from you are making this claim, how your father got it, your grandfather got it. Unless you tell them and give them proper direction, they will not give you the materials. So this is a very difficult position as far as civil matters are concerned. A client may not know at all what is the nature of a case which he has to place before the court. So when the appeal comes, it is our own duty to see that if there is some issues which are made out by the party but not supported by evidence. He might have come with a specific case saying that this is how I have right, but he may not be able to connect it, but he may not know about it. So what we have to do is at least try to give him the direction by which you can gather the information, place it before the court. When he fails to do it, that we are not able to help them. But when the matter comes up in the court, the trial court judgment is not looked first. The court only looks at the pleadings, evidence, documents, everything is read. I remember before Justice Ramprasad Rao's bench, the judge goes through the plaint, asks us to read the written statement, what is the defense you have taken, then goes to the issues, then say what are the findings given by the court. They don't read the judgment. Findings they will ask. Then hear the matter fully. Oral evidence is fully read. These days, oral evidence are not fully read by courts. I find they only ask for a particular page. What is this? What is that he has said? Let me show that page. Only small items they finish it. But unless you read the whole evidence at a stretch, you cannot even come to a conclusion what that evidence conveys to you. So the judgment appreciation of that evidence is most important. So the duty of the appellate court is to see each and every document filed before the court, the oral evidence as well as the nature of pleading. After that, it may come to a conclusion. This is what is the position. How come the trial court either granted this decree or refused to grant the decree? Then issue arises. Then they go to the judgment. They can't just ignore the judgment of trial court. They will have to look at it and see whether the trial court has given any reason which they can find fault with. Suppose two reasons are possible, two opinions are possible on a particular issue. Then the appellate court will have to think whether the reason on which he is to decide the case is a better reason than the other one. And finally, a decision is given. Otherwise, you must say how the finding of the trial court is wrong. Without saying that, you cannot reverse the judgment. Merely saying the trial court has held everything wrong, this right decision is so and so, and reverse the judgment. So the first appellate court's duty is like that. I have picked up some decisions which clearly deal with this particular issue only, section 96 appeals, how the courts will have to deal with. First, I would like to refer to the case of Kerala judgment of Justice Krishnaiyer. Probably most of you must have read about this long time back. This is reported in AR 1969, Kerala 316. This is followed later by several high courts and Supreme Court also. I just want to read one paragraph. This holds good today also. That's why I thought of referring to this first. In para 6 of the judgment, this is what the judge says. It is the appellate court's function not to find out whether there is perversity in the trial court's judgment, but whether it is wrong. There is a very wide difference between a wrong conclusion and a perverse conclusion. A restricted revisional jurisdiction may be invoked under certain statutes only where there is a perversity in the findings, but the wider appellate jurisdiction conferred under section 96 of CPC demands a little more effort on the part of the appellate court in going into the evidence to come to its own conclusion and reversing the trial court's decision if it is found to be wrong. Be it for me to suggest that I even hinted at the trial court judgment being wrong in the case. That is a matter entirely for consideration by the appellate court. The interest of justice, therefore, require that the judgment and decree of the court below should be set aside and the appeal sent back for fresh disposal by subcourt of Kottayam. So in this case, he remands the matter, highlighting the fact that the judgment is wrong, therefore I sent it back for consideration. But most important is, under section 96, what the language says, it demands a little more effort on the part of the appellate court in going through the evidence to come to its own conclusion, reversing the trial court judgment. So you can't just follow what is stated by the trial court and give a decision. It should be something more than that. You have to independently assess your evidence and come to a conclusion, then only you can reverse the case. That's the view taken by the Honorable Kerala High Court. This is Krishnaiyer judgment. This is followed in a number of other cases. But one other matter which I would like to refer is the leading case in 2001, 3 SCC, page 179. You can specifically note para 11 and 12 because they deal with only this. I'm not referring to the facts of the case, only the legal issue only I will want to refer here. This subject cannot be over in 45 minutes. because I would like to refer to some factual details and all that in some cases, but I today, because I'm not 100% fit, I'll refer only to this case law and highlight those portions which will be real, which will have real help to all the juniors. When you read an appeal, you please read these judgments, then read the evidence, read the pleadings, read the issues, and then read the judgment. Then you will know where the judge has committed wrong, how you can place the grounds in the appeal under section 96. This is what they say in this judgment, para 11 of the judgment. I'll read only a portion. This was creating confusion in the minds of the public as to the legitimate scope of second appeal under section 100 and had burdened the high courts with an unnecessarily large number of second appeals. Section 100 was therefore suggested to be amended so as to provide that earlier. Sorry. Sorry. Okay. Suggested to be amended so as to provide that right of second appeal should be confined to cases where a question of law is involved and which question of law is substantial one. The select committee to which the amendment bill was referred felt that the scope of second appeal should be restricted so that litigations may not drag on for a long period. Reasons, of course, are not required to be stated for formulating any question of law under subsection 4 of section 100 code, though such reasons are recorded under proviso to subsection 5. Then next para, the phrase, because this is actually a section 100, I thought they are also dealing with the 96, but I prefer to read this having taken it for consideration now. The phrase substantial question of law as recurring in the amended section 100 is not defined in the code. The word substantial as qualifying questions of law means of having substance, essential, real, of sound worth, important and considerable. It is to be understood as something in contradiction with technical, of no substance or consequence, or academic merely. However, it is clear that the legislature has chosen not to qualify the scope of substantial question of law by suffixing the words of general importance, as has been done in so many other provisions, such as section 109 of Code of Article 133, 133 of Constitution. The substantial question of law on which a second appeal shall be heard need not necessarily be a substantial question of law of general importance. In so-and-so case, the phrase of substantial question of law as it was employed in the last clause of the then existing section 110 came for consideration, and the lordships held it did not mean a substantial question of general importance, but a substantial question of law which was involved in the case as between the parties. Some other cases were quoted, and ultimately they say a point of law which admits of no two options may be a proposition of law, but cannot be a substantial question of law. To be substantial, a question of law must be debatable, not previously settled by law of the land or a binding precedent, and must have material bearing on the decision of the case if answered either way, insofar as the rights of the parties believe before it are concerned. To be a question of law involving the case, there must be first a foundation for it laid in the pleadings, and the question should emerge from the sustainable findings of fact arrived at by court of facts, and it must be necessarily to decide that question of law for a just and proper decision of the case. An entirely new point raised by the first time before the High Court is not a question involved in the case unless it goes to the root of the matter. It will therefore depend on the facts and circumstances of each case whether a question of law is a substantial one and involved in the case or not. The paramount overall consideration being the need for striking a judicious balance between the indispensable obligation to do justice at all stages and impelling necessity of avoiding prolongation in the life of any of these lists. See, the point is, the basic issue should be there in the issues which you raise in the suit itself. So unless that basic issue is faced, then only you can place the real factual basis to support it to any question of law that may arise in the later part of the litigation. So this is how the Honorable Supreme Court has said what a substantial question of law is. General importance is not the issue, which is applicable to other provisions. Then they say, a perusal of the judgment of trial court shows that it has extensively dealt with the oral and documentary evidence adduced by the parties for deciding the issues on which the parties went to trial. It also found that in support of this plea of adverse possession on the disputed land, the defendant did not produce any documentary evidence, while the oral evidence adduced by the defendant was conflicting in nature, hence unworthy of reliance. The First Appellate Court has, in a very cryptic manner, reversed the finding on question of possession and dispossession as alleged by the plaintiff, as also on the question of adverse possession as pleaded by the defendant. So this is what they say, and ultimately Supreme Court remands the case in this case also. The issue basically to be placed before the court is what exactly is the point on which an appeal to be heard by the court. So you frame the points for determination. 1, 2, 3, 4, 5, you raise the points for determination. Based upon that, the court has to consider each and every point and give a finding. While giving that finding, if you are able to find that there is an error, basic factual details are not covered by the learned judge while deciding the issue, then you have a right as a substantial question of law for a second appeal. But the one and only thing you have to decide in an appeal is whether the judge has considered all the matters placed by the court and the points raised relatable to the issues raised in the case. Without deciding that, if the appellate court decides an issue, the verdict will go back for reconsideration. That's what the Supreme Court said in 2 or 3 cases later. One more case which I thought I will refer to regarding section 96 is 2001 4 SCC 756, para 5. See, this is the questions raised in that case, whether the relationship claimed by the parties is true, whether the plaintiff is entitled to declaration as prayed for. These are the 2 points raised. Then when the court considers that, this is what the Supreme Court points out. We have carefully perused the judgment and decree of the High Court in the first appeal. We find that substantial documentary evidence had been placed before the trial court, including certified copies of certain public records, besides copy of the judgment and decree of the earlier suit in OS number so-and-so. Oral evidence had also been let in by parties before the trial court, which was noticed and appreciated by the trial court. However, the impugned judgment in the first appeal is singularly silent of any discussion either of documentary evidence or oral evidence. Not only that, we find that though the trial court had dismissed the suit on the ground of limitation, as also on the ground of the rescission of the earlier suit in so-and-so operated as res judicata against defendants owned only, High Court has not even considered, much as discussed the correctness of either of these 2 grounds on which the trial court had dismissed the suit. Sitting as a court of first appeal, it was the duty of the High Court to deal with all the issues and evidence led by the parties before recording its findings. It has failed to discharge the obligation placed on the First Appellate Court. The judgment under appeal is therefore cryptic and none of the relevant aspects have been considered. Therefore, they set aside and send it back. So most of the cases are on the same line. But up to 2022, we have cases why it is going on saying the same thing repeated, still problems arise in second appeal. I'll only give the citations, please note it. 2010, 13 SCC 530, this is a case where the court decides the issue without framing the points for determination in Order 41, Rule 31. See, there are cases which says there is no need to frame the point if the judgment clearly indicates the basis on which a decision is given. Because from the judgment itself we can find out whether there is an assessment. The decision is based upon certain specific points. In those circumstances, Supreme Court has taken one or two cases, there is no need to send it back. But there are instances where they don't frame the point, therefore the judgment doesn't indicate that on what point they have taken a decision. In those cases, this judgment says it has to go back. Then 2022, 3 SCC 150, paragraph 22. This deals with the mainly section 100. They refer to the earlier case on the subject, and in para 22, this is what the Learned Supreme Court said. The first aspect to be taken note of is that question of law ought to have been framed under section 100 of the Code of Civil Code. Even if the question of law had not been framed at the stage of admission, at least before deciding the case, the said question of law ought to have been framed. We may refer to usually to one of the, they quote one of the reasons. Why I am referring to this is, there is a regular thing happening in our court. They order notice of motion in second appeals. So respondent gets the notice. He doesn't know on what point they are going to hear the matter, but they have to appear. And this matter is sometimes heard as a regular second appeal is being heard, without point being framed. Some judges say, no, I'll frame for the point, so I'll give you time. That is also happening. But whether it is justified in asking a respondent to come before court, even before court finds that there is a case for consideration. If I remember correct, 1995-96, at that time, this notice of motion issue started in second appeals. Sometimes when they order notice, the records come here, because some judges call for the records also. So automatic stay, no admission, only notice of motion, records called for. So without admission, stay. So this is what is happening. So 2-3 occasions I myself raised that objection, saying no. First you must tell me on what ground you are asking me to come and answer. It is not there. You are asking the party to come, just prepare everything, argue, then you take a decision, this is a law point. The appellant has to make out a case on law point, not the respondent. So hear me and then frame a point, that's not okay. It's not justified. But even now there are number of cases being posted for admission as notice of motion cases. 2013-14, Lakshmanarayan J, I found almost every 2013 case was ordered notice of motion. Then he frames a point, after that the matter is heard. So this procedure is regularly followed here, which has to be probably thwarted for two reasons. One reason is that respondent should not unnecessarily waste his time in a question of fact case. Law point இருந்தாலும் வந்துட்டு பேசலாம்னு சொல்லலாம். Question of fact சும்மா வந்துட்டு ஒரு advocateக்கு fees வரும், of course. But it's not okay. As far as second appeal, old matters are still pending. Why have so many notice of motion cases? If you find a case, you admit and ask the respondent to come and answer, which is not happening. All these cases repeatedly say the same thing. Don't do this, don't do this, don't do this. But somehow our court, I don't know, present stage, இப்போ இருக்கிறவாலாம் அட்மிட் பண்ணிருக்காங்களா? நோட்டீஸ் ஆஃப் மோஷன் தானே இப்போ? அதுதான் கொஞ்சம் கஷ்டமாக இருக்கு. See, to answer the client sometimes is very difficult. Why it is posted கேட்கறதுனா ரொம்ப doubtful, and the sometimes notice of motion ordered by one judge, but it comes for a hearing before another judge. So, and when you go and argue, other side takes time. Let's say notice of motion, I let hear him also, so the matter gets adjourned. So these are all things happening the last 2 years I am seeing. So this procedures to be modified, and this appeals to be listed, and see to it that it is disposed of without delay. Admission. ಇಲ್ಲ ಅಡ್ಮಿಷನ್ அதாவது நோட்டீஸ் ஆஃப் மோஷன் வந்தப்புறமா அட்மிஷன் ஃப்ரேம் பண்ணுறோம். பிடிஆர் ஷார்ட்டை புதுசாக வர கேஸில் வரதா தெரியாது. பிடிஆர் ஷார்ட்டை if I remember correct, in the last 3 months. ஆமாம்.
Some judges from the appellate side practice பண்ணவங்களுக்கு they follow the framing of the law.
Yeah, that's most important. Number of cases without knowing what the law is, you come to court and stand before the judge. So this section 96 and 100. 96 is an issue where, as I said, the appellate judge will have to sit as a trial judge to hear the whole matter. As a fresh suit, he has to hear the whole thing. He can't pick and choose some portion and say, no, this is sufficient, there is no need to go. See, assessment of evidence is most important. See, one sentence, it may be favorable to me, it may look favorable to me, but when you read the whole evidence, the scenario will change. That is what was happening, and those days, every judge, they read the whole evidence, especially when tough issues on facts arise. They analyze evidence of each witness, who is really speaking the truth, who is not speaking the truth. They assess from reading the whole evidence. So these days I don't find that kind of assessment of evidence. In fact, about 5-6 years back, 3 months later, 250 first appeals were disposed of by a judge. Definitely it's not possible. As a civil lawyer, I know it's not possible unless you concede. I have no case. So how can 250 appeals, first appeals, be disposed of in 3 months? 3 months and 5 days a week. But some cases, when you want to read the evidence, judges say, no, you only pinpoint the point. See, unless assessment of evidence, how it takes place, only when you read the whole thing. Whether that man bluffs or he really speaking the truth, he can be assessed only by reading the whole evidence. You can't just judge from one paragraph or one sentence where he might have said something. Recording itself may be a mistake. We do not know. Sometimes the clients later come and say, no, I never said like that. But they sign it. So we have to support saying, no, you have signed. You have to. But when you assess the whole evidence, the truth is found out. Therefore, my sincere attempt is, as juniors, when you prepare the appeal grounds, you must study the entire case yourself. Because as I said, judge has to do it as an appellate judge. But as a lawyer, you must do the same thing. You must prepare every piece of evidence, sit with the client, understand what the facts is, then prepare the grounds. If you do that, 50% of the case, definitely you will win on your own grounds of appeal. If you don't do that, you will struggle when you go and argue before the court. The important thing is you must try to gather all the papers filed before the court from the clients. Without the evidence, without the documents, don't get ready for the appeal. Sometimes when we are not having it, we try to get it from certified copy from the High Court and do it. So this should be the approach for juniors. You read the whole thing fully before preparing the appeal grounds. If you don't study that, then you will not find a ground at all. Because the appellate trial court judge will find to be correct for you, because you have not read the whole thing. So to say that he is wrong, he has committed a wrong somewhere, you should have read the whole paper, then only you can point out that mistake, otherwise it's not possible. So the principally section 96 you will have to do that. For section 100, substantial question of law, you will have to again study the facts and try to gather on the facts whether you can bring some law into it. Sometimes you will not get, the whole thing will be facts, but perverse findings will be there. That they say substantial question of law, some cases that if it is perverse, you can reverse. That it can be a substantial question of law. So, even to say it is perverse, you must have the materials with you. To say that this is how the evidence is, but the judges looked at it in a different form, it is perverse. That is why the whole evidence is lost. If he commits mistake in one, it may be a chain reaction for him to say everything on the same basis. So if the first mistake he committed is, we are able to show it's wrong, probably rest of it will, you will be able to get over and see that you get a point on law. Therefore, the issue here, as far as first appeal is concerned, consideration is slightly different. As far as second appeal is concerned, your preparation should be, after reading the whole thing, you must assess on your own self what exactly is the case is, whether you can fit into some issue which can be made as a special law. I mean, substantial question of law. Because so many cases they are reversed, saying that perversity, they have not considered this, but specifica, they don't say what was the perversity, what was the legal issue, they committed a mistake. Some cases they don't even say that. It was general statement and they remand the matter. But according to me, to frame a point of law, you should have the whole facts in your hands. Then you will have to sit and think about it. You can't, otherwise facts will definitely give you a problem in a second appeal. So facts lens, you will have to think about it and what kind of legal issue you can raise based upon that fact, you will have to study. Sometimes reading a judgment may give you some lead on that. Because factual court may say that is a question of fact, I am not going to interfere. Detailed judgment will be there. But there may be some issues there which will they highlight, saying that no, in this issue I cannot, on these facts, hold in your favor. But when if you are able to put your facts into that position, in that particular law, probably you may succeed. But that is where you will have to read the whole thing, then think about the facts. On these facts, whether I can get any law point. Otherwise, it's very difficult, because section 100 is, even earlier, Justice Veerasamy will dismiss my second appeal in one sentence. No question of law, dismissed. He writes like that, only one line. You can do nothing. But if a substantial question of law, we are taking real pains to see that some law is, we get into the grounds. So it takes time. I don't think it is easy to frame a point of law under section 100. It's really a difficult provision made, and when people are unable to go to Supreme Court, they really struggle. When the Appellate Court just confirms the decree, sometimes on facts. So you as a lawyer, you will have to find a source to see that a second appeal is get admitted, so that reassessment of evidence, a point of law may arise. Because that's also one or two cases they say. Factual details based on it, they subsequently say, no, this is what the judge should have done, which he has not done. So they have reversed some cases. Supreme Court law. There are instances where legal issues, there are mistakes committed. There may be two judgments on same law. Adamai varumbodhu, the difficulties expressed by the court, then you will have to persuade the judge. The two views are contradictory, you must refer to a third judge. The number of cases are there, you should be prepared to have it in your hand before you go before court and make a submission on that. Then the other point which arose is because of the recent amendment to the Succession Act, Supreme Court has now held that you must take note of change in law also. Even the pendency of the proceedings, if there is a change in law, you must give effect to that in the judgment. You can't just say, I won't take note of it. Section 6 of the Succession Act. So these are all matters which you will have to consider. Apart from these two provisions, there are so many under Order 43, Rule 1, number of orders you have to come on appeal. These are all orders, but it's not conclusive. But materially, the appeal is filed to set aside an order. For instance, Order 39, Rule 1, you seek an injunction. Sometimes injunction is granted. You can file an appeal only if you are able to show the balance of convenience is not in favor of the plaintiff. No injury is caused to him. So wrongly injunction is granted, you can file an appeal. If you are unable to show that, then injunction will stand. Similarly, if the injunction is rejected, the plaintiff will have to establish how injury is caused to him, irreparable injury is caused to him, how balance of convenience in his favor. All these factors you can place in appeal. Similarly, receiver. Suppose receiver you asked and not granted, appeal is provided. Then execution proceedings, there are orders. Attachment proceedings, there are orders. All that you have to satisfy that the requirement of law is satisfied. Therefore, the order not granting it is illegal to file appeals. There are also proceedings under the execution where claims are made. After the decree is passed, when execution is levied, third parties come and obstruct delivery. There now the law is that obstruction you will have to consider as a suit only. So the separate suit is not bindable. It is the claim petition is considered as a separate litigation, and a decree passed therein is a regular appeal is provided under the court. Therefore, these are all the matters which generally come under the jurisdiction of the civil appellate jurisdiction. Reading the civil lawyer, reading is most important in civil matters. You don't read fully, you will miss the bus. The number of occasions while even arguing a matter before the court, you may get a point. Because judge will put you a question. You might not have considered that. But once you hear that, you will feel, oh, I missed this point. I'll have to study this. I can place this point. Other than, instances have come. So your concentration should be materialistically on your facts. So on the facts based panida, you can always prepare a case and try to give success to your client. If you fail on that, very difficult, either under 96 or 100 to succeed. Facts. And you must guide your clients also. Sometimes they may not give the full particulars to a trial lawyer. So whatever is available, they bring and file a suit. So ultimately they fail. But as an appellate lawyer, you may come across some position. You may guide him, get materials. Order 41, Rule 27 is there. You can explain why it is not filed when the original suit was filed by the party. Get success through that documentation also. Several cases have happened like that. Even Supreme Court level, Order 41 Rule, similar documents have been received by Supreme Court. If I remember correct, in HRNC matter, Supreme Court remanded the matter after receiving certain documents at that stage, and the matter was reheard by the High Court. But again, it was HRNC Board lost the case matter. That's a different issue. But they felt there is a point. Therefore, they allowed 8 documents to be filed and remanded the matter. Therefore, that thing also should be in your mind to help your client. When he comes with the cause saying that I lost my property, this is the we will have to definitely try to help him. That should be also our motto as a lawyer. Order 21, Rule 58, Order 21, Rule 97, 99. These are all claim petitions arising out of in the course of execution. Then a decree passed there is appealable, just like a suit. Is 2017 and the SEC also some interesting case. 2017, 2 SEC 415 and paragraph 12 to 14. When judges decide on first appellate court's jurisdiction, how to deal with the property, deal with the case. They say, as per 4131, they refer to that and say, treats as under the points for determination, decision thereon, the reasons for the decision, where the decree appealed from is reversed or varied, the relief to be which the appellant is entitled to. These are all things to be provided. An appellate court is the final court of fact. Judgment of the appellate court must therefore reflect the court's application of mind and record its findings supported by reasons. The law relating to powers and duties of the first appellate court is well fortified by legal provision and judicial pronouncement. Considering the nature and scope of duty of the first appellate court, in Vinod Kumar's case, so and so it was held, that is the case which I referred earlier. They quote there and follow another case, S.K. and Swami, Jagannathan Arulappa case, and para 14 point which arise for determination by court for first appeal must cover all important questions involved in the case, and they should not be general and vague. Even though the appellate court would be justified in taking a different view on questions of fact, that should be done after adverting to the reasons given by the trial judge in arriving at the finding in question. When the appellate court agrees with the views of the trial court on evidence, it need not restate effect of evidence or reiterate reasons given by the trial court. Expression of general agreement with the reasons given by the trial court would ordinarily suffice. However, when the first appellate court reverses the findings of trial court, it must record the findings in clear terms, explain how the reasonings of trial court are erroneous. So this is the sum and substance, the principle on which the appellate court has to decide a appeal. When I took the digest on 2022-23, there are about 10 or 15 cases on the same issue. Substantial question of law, section 96. No, they வந்துட்டே இருக்கு கோர்ட்ல, ஏன் தெரியல. But of so many decisions, there are so many. This is Ibrahim Khalifullah case. He has dealt with all the cases. 2015 1ACC 391. He dealt with almost all the cases in this in para 10 to 20. So many cases have come saying that's how the first appeal to be decided by the appellate court, first appellate court. But still, there are cases going to Supreme Court where Supreme Court says it's not done correctly, then back. அதுக்கு எதா பண்ணலாமா? 2015, 1ACC 391, para 10 to 20. இப்போ ஆக்சுவலாக சொல்கிறதுல சில கேஸில் இட்ஸ் தி ரீசெண்ட்லி இன்னும் முடியல அந்த கேஸு. என்னோட ஜூனியர் தான் என்கேஜ் பண்ணார், கார்த்திக் ராஜா. அதில் வந்து 2 கோர்ட்டில் லாஸ்ட். கடைசியில் ரெக்கார்ட்ஸ் எல்லாம் இருக்கல. ஸோ ஐ ஆஸ்க்ட் ஹிம் டு கெட் ஆல் தி ரெக்கார்ட்ஸ், சர்டிஃபிகேட் காப்பி வாங்கினா வந்து பார்த்தா அந்த இந்த டாக்குமெண்ட்ஸ் எல்லாம் எதுக்கு ஃபைல் பண்ணிருக்கு கோர்ட்டில் ஒன்றுமே இல்லை. 2 கோர்ட் ஜட்ஜ்மெண்ட்லேயும் 2ம் இல்லை, ஒன்றுமே இல்லை. அத்தனை டாக்குமெண்ட்ஸ் போட்டிருக்கா. அதெல்லாம் ஹவு இட் ஹேப்பன்ஸ்னு தெரியல. ஃபர்ஸ்ட் செப்பரேட் கோர்ட் வந்து கரெக்ட் பண்ண வேண்டியது கரெக்ட் பண்ணாதிக்கு அப்படியே இயர் அடிச்சான் காப்பி. எஸ் ராமச்சந்திரர் யூஸ் டு சே, எங்கள் அப்பா யூஸ் டு சே, கங்கரன் ஜட்மெண்ட்னா அட்மிட் பண்ணுவான். ஏன்னா பார்த்துருக்க மாட்டான் சும்மா அப்படியே. பட் ரிவர்சிங் ஜட்ஜ்மெண்ட்னா தகராறு பண்ணுவான், அப்ளை பண்ணுறோம் ஒரு மைண்டுன்னுட்டு ஃபாதர் யூஸ் டு சே. ஸோ அது மாதிரி திங்ஸ் வேர் லைக் தட் தென். இப்போ நவ் when some of the cases we find evidence document is not looked into, evidence is not looked into, and client has to
first appeal subordinate courts only they say you give written arguments, I will go through, I will pass out.
அது ஃபர்ஸ்ட் நிறுத்தணும், அது ஃபர்ஸ்ட் நிறுத்தணும்.
reading the plain, reading the written statement and habit has gone.
இல்ல பட் அது கூட see some I used to do some matters in civil court recent past. எனக்கு ஐயோ பாவமாக இருக்கும் அந்த ஜட்ஜஸ்லாம் பார்த்தா. அவங்களுக்கு முதல்ல இந்த ஃபேனு தான் போட்டிருக்கான். இந்த ஃபேனை போட்டு உட்காத்தி வச்சிங்கன்னா புசுன்னு இருக்கு. அங்கே 15 நிமிஷம் உட்காந்தா கூட உனக்கு இருக்க முடியாது. அது மாதிரி இருக்கு ஹால், அவ்வளோ சூடு சம்மர்லலாம். அவங்களுக்கு வந்து எத்தனை மேட்டர்ஸ் போடுறாங்க, இம்பாசிபிள். ஜட்ஜ் கேனாட் லுக் இன் டு சோ மெனி மேட்டர்ஸ் ஆன் அ டே அண்ட் ட்ரையல் கோஸ் ஆன் ஃபார் செவரல் டேஸ். அந்த ஜட்ஜுக்கு ஒன்றுமே ஃபாலோவே பண்ணியிருக்க மாட்டாங்க. என்ன ட்ரையல் நடக்கிறது கூட தெரியாது, என்னத்துக்கு இந்த இஷ்யூ ரைஸ் பண்ணுறாங்க, என்ன பாயிண்ட்ல போட்டிருக்கான், ஒன்றுமே தெரியாது. ஒரு செகண்ட் அப்பீல் இப்போ நடத்துறதுல பிடி ஆஷா மட்டும் 14 வருஷத்துக்கு ஓரல் எவிடன்ஸ் எடுத்திருக்காங்க. 14 years. ஐ டைப்ட் அவுட் அண்ட் கேவ் இட் டு ஹர். திஸ் ஷுட் நாட் பி தி. என்ன இஷ்யூனே கிடையாது. இஷ்யூ இருக்கிறது 4 இஷ்யூ தான். இவங்க பாட்டு அப்பப்போ போட்டு ஒரு அப்ளிகேஷன் போடுறாங்க, ஒரு ரீஓப்பன் பண்ணுறாங்க, ஓரல் எவிடன்ஸ் எடுக்கிறாங்க. அதுல வேற எல்லாமோ பேசிட்டு இருக்காங்க. அதுக்கும் ஒரிஜினல் சூட்ல ப்ரீடிங் இஷ்யூக்கும் கனெக்ஷனே கிடையாது. இதெல்லாம் வந்து ஹவு டு ரிசால்வ் இட்டுங்கிறது ஒரு பெரிய ப்ராப்ளமா இருக்கு, பார்க்கணும் எல்லாமே. அதர்வைஸ் சபார்டினேட் ஜுடிஷியரி ஹஸ் நோ டைம். சோ மெனி கேஸ் அவளுக்கு எக்ஸ்க்ளூசிவ்லி ட்ரையல் ஜட்ஜின்னு ஒரு 10 பேரை உட்காந்து வச்சு ஒன்லி தே ஷுட் டு ஒன்லி ட்ரையல் ஒர்க் அண்ட் தே ஸ்டார்ட் டு டூ இட் கண்டினியூஸ்லி. இந்த ஓரல் எவிடன்ஸ் சீஃப் எக்ஸாமினேஷன் 8 எழுதி இப்போ நல்ல அஃபிடவிட் போட்டோம்னா ஒரே இதில் முடியுது. இந்த கிராஸ் எக்ஸாமினேஷன் அது பாட்டு கண்டினியூ ஆகுது. ஒரு 2 பக்கம் பண்ணுறதுக்குள்ளே இன்னொரு கேஸ் எடுத்து அதுக்கு 2 பக்கம் எடுக்கிறாங்க. இது என்ன பிரயோஜனம்? ஜட்ஜியே ஃபாலோ பண்ண முடியாது. என்எஸ் ராமசாமி, ஜஸ்டிஸ் என்எஸ் ராமசாமி, ஐ யூஸ் டு டெல் மை ஜூனியர்ஸ், அவருக்கு வந்துன்னா ட்ரையல் எடுத்தோடனே ஃபர்ஸ்ட் ரீட்ஸ் தி பிளெயின்ட் அண்ட் ஸ்டேட்மெண்ட் இஷ்யூஸ், தென் சே கமான் புட் தி விட்னஸ் இன் தி பாக்ஸ். எவிடன்ஸ் கிராஸ் எக்ஸாமினேஷன் ஆகிடும், நெக்ஸ்ட் விட்னஸ் உடனே போடணும். ஸோ கண்டினியூஸாக நடக்கும். நடந்துட்டு நெக்ஸ்ட் டே இட் இஸ் போஸ்டட் ஃபார் ஹியரிங், ஆர்குமெண்ட்ஸ் ஹர்ட், ஜட்ஜ்மெண்ட் ப்ரொனவுன்ஸ் தட் டே. ட்ரையலில் கீழே இந்த இப்போ 21வது கோட்டம் 22வது கோட்டம் அங்கே தான் உட்காந்துருப்பார் ட்ரையல் நடத்துறது. அதெல்லாம் இப்போ இல்லவே இல்லை. நயனார் சுந்தரம் இப்போ 2-3 மேட்டர் ஐ ஹவ் சீன். ஐ வாஸ் ஆல்சோ இன்வால்வ் இன் ஒன் கேஸ். அது பாட்டுக்கு ஒரு 14-15 days கண்டினியூஸ் ட்ரையல் ஆஃப் ஒரு கேஸ். 14-18 விட்னஸ் எக்ஸாமின் பண்ணுறாங்க. எல்லாம் கண்டினியூஸ், ஒன்றுமே டிலே பண்ணுறது கிடையாது. அந்த அதர் ஹேண்ட் ஒரு ஸ்பெசிஃபிக் ஃபார்ம்ஸ் விட்டு வள்ளிநாயகம் வாஸ் தி கவுன்சில் ஃபார் ஹூம் ஐ அப்பியர்ட். 9 வருஷம் 8 ஜட்ஜுக்கிட்ட ட்ரையல் நடந்திருக்கு. 3 செட் ஆஃப் 2 டிஃபெண்டன்ஸ் கான்ட்ரா ஒரு பிளெயின்டிஃப். 3 பேரும் ஒரே டாக்குமெண்ட்டை திருப்பி போட்டிருக்காங்க. படிச்சுனே வருது என்ன இடம்னா பழைய முன்னாடி படிச்சோம்னு பார்த்தா அவன் ஒன்று மார்க் பண்ணிருக்கான், இவன் ஒன்று மார்க், ஒருத்தருக்கு ஒன்றும் தெரியாது. அது 9 வருஷம் ட்ரையல் நடந்திருக்கு. இது மாதிரி நிறைய கேஸ் வருது. இதுக்கு வந்து ஐ திங்க் நம்ம வி மஸ்ட் ஹெல்ப் தி கோர்ட்ஸ் டு ஹியர் ஒன்லி ட்ரையல் ஒர்க். ஒரு 10 கோர்ட் ஒன்லி ட்ரையல் ஒர்க்குன்னு போட்டு உட்காந்தா தான் இது மாறும், இல்லாட்டா மாறவே மாறாது. வளர முடியாது. இட் இஸ் நாட் பாசிபிள். நம்மளே உட்காந்து ஒரு நாள் படிச்சேன்னா அடுத்த நாள் மறந்து போயிடுறது, இன்னொரு வாட்டி எடுத்து கிளான்ஸ் அடிக்க வேண்டியிருக்கேன். அது மாதிரி இருக்கும்போது ஜட்ஜி அவன் அத்தனை கேஸ் வச்சுன்னு என்ன ஞாபகம் இருக்கும்? இல்லை முடியாதுங்கிற. படிக்கணும்ல, படிக்கிறதுக்கு டைம் கிடையாது. ஆஸ் அ சபார்டினேட் ஜட்ஜு அவன் வீட்டில் போய் உட்காந்து படிக்கணும்ல. மாஸ்டரா அது ரொம்ப தப்புங்க. வந்தாச்சு இதெல்லாம் என்ன பண்றது? ஆமான்னு சொல்லிட்டாங்க எல்லாமா. அதை விட மோசமானது எதுவுமே எல்லாத்தையுமே வில் ப்ரூஃபுக்கு அப்டவுட் போடுறான். யாரோட அப்டவுட்? அது அட்வொகேட்டோட அப்டவுட், கிளைண்டோட தான். அது பாதி பேருக்கு அதை பற்றி கேட்டால் தெரியல. 2 எமினன்ட் டாக்டர்ஸ் ஒரு இதில் கிராஸ் எக்ஸாமின் பண்ணேன். அவங்களுக்கு அந்த அப்டவுட்ல சொன்னதுக்கும் அவங்க பேசுறதுக்கும் கனெக்ஷனே இல்லை இருக்கு. 2 பேரும் எஸ்டாப்ளிஷ் டாக்டர்ஸ். இப்போ அந்த வில்ல ப்ரூவ்லன்னு வரும். ஸோ ஐ டோன்ட் நோ, அந்த ப்ரூஃப் அப்டவுட் தியரி இட் செல்ஃப் இஸ் பேட். ஏன்னா அப்டவுட் மாதிரி போட்டுடுறோமே, கொஸ்டின் மார்க் மாதிரி இருக்கணும். அவன் சீஃப் எக்ஸாமினரே தப்பு பண்ணலாமே, வக்கீல் சொல்லி கொடுத்தது தானே சொல்ல முடியும். ஆமாம் ஆமாம் ஆமாம். இல்லை அதே தான் பிளைண்ட் அப்படியே ரிப்பீட் பண்ணிடுறாங்க. சில சமயம் பிளைண்ட் படித்து அந்த சமயத்தில் ப்ரிப்பேர் பண்ணுற அட்வொகேட்னது ஏதோ பாயிண்ட் இருக்கும் போல் இருக்கேன், வேறு போடணுமே அப்படி வேறு அடிஷ்னலாக கூட வரலாம். வாட் இஸ் நாட் தேர் இன் தி பிளைண்ட் ஆல்சோ வில் கம் இன் த proof affidavit. These are all defects in the system which has to be cured. இல்லைன்னா சிவில் அப்பீல் சைட்லாம் எங்கேதோ போயிடும், ஒன்றுமே பண்ண முடியாது. கமர்ஷியல் காசஸ் மேபி, பிகாஸ் தட் இஸ் அ டிஃப்ரெண்ட் இஷ்யூ. பட் இந்த ப்ராப்பர்ட்டி ரைட்ஸு இதெல்லாம் வர்றதுக்கு சிஸ்டத்தையே கொஞ்சம் மாற்றணும். அண்ட் ஜட்ஜஸ் ஷுட் ஹாவ் இண்டிபெண்ட் ஒர்க் ஃபார் ட்ரையல் ஒர்க். இந்த இன்ஜெக்ஷன் அப்ளிகேஷன் அது இது நோட்டீஸ் எல்லாரும் பென்ஷன் இதெல்லாம் போட்டு 1 மணிக்கு அப்புறம் தே ஜஸ்ட் கோவே. தென் மத்தியானம் நாங்களாம் வருவோமான்னு வெயிட் பண்ணிட்டு இருக்காங்க. நம்ம போனப்புறம் வந்து உட்காடுறோம். அதெல்லாம் இருக்கு. அதுவும் நானும் தப்பை பண்ணேன் ஒரு வாட்டி. அது நடக்கிறது. நம்ம வரலன்னு எழுந்து போகிறது இல்லை. வர சொல்லுங்க நான் கேட்குறேங்கிறாங்க, அதுக்கப்புறம் கேட்குறாங்க. பட் அவங்களுக்கு டைமே இல்லை. ஐ ஃபைண்ட் வெரி டிஃபிகல்ட். நிறைய இருக்கு, முடியாதுங்கிறேன். நம்ம ஒரு 2 கேஸை பிடிச்சிட்டு அடுத்த நாள் இன்னொரு கேஸ் கேட்டால் அட்ஜென்மெண்ட் வாங்குறோம். அவ்வளோதான் முடிகிறது. வாங்க முடியாது. ரிசர்வ் பண்ணிட்டு போவாங்க, அவஸ்தைப்பட்டு ஒரு வாட்டி போட்டு. இங்கே ஹைகோர்ட் ஜட்ஜஸே இப்போ ரீஹியரிங் போட்டுக்கிறாங்க. 3 மாதம் முடியலன்னு ரீஹியரிங் போட்டு 2-3 மாதம் கழிச்சு தான் ஜட்ஜ்மெண்ட் சொல்கிறான். அப்படி இருக்கும்போது இங்கே உங்களுக்கு அட்லீஸ்ட் ஹைகோர்ட்டில் மேட்டர்ஸ் ஆர் ஹர்ட் ஃபுல்லி. ஒரு மேட்டரை ஃபுல்லாக கேட்டுடுறாங்க. அங்கே அது முடியறது இல்லை. தட் இஸ் வை தீஸ் ப்ராப்ளம்ஸ் அரைஸ் இன் மோஸ்ட் ஆஃப் தீஸ் அப்பீல்ஸ். அதர்வைஸ் இவ்வளோ தப்பு வர சான்ஸ் கிடையாது. Basically, we will have to think of to help the clients. We must have courts hearing trial work independently. They should not be allowed to sit for other matters. இப்போ மோட்டார் கிளைம்ஸ்னா அதுக்கு ஒரு இது கொடுத்துட்றாங்க ப்ரெஃபரன்ஸ். சம்டைம் டிஸ்ட்ரிக்ட் கோர்ட்டில் செஷன்ஸ் கேசஸ் தான் ஃபர்ஸ்ட் ப்ரெஃபரன்ஸு. ஸோ இந்த மேட்டர்லாம் லாகம் போயிடுறது. நடுவில் இல்லைன்னா டைம் இல்லைன்னா ஒரு 5 நிமிஷம் ஏதோ நடத்திட்டு திருப்பி இன்னொரு போட்டுறாங்க. ஸோ திஸ் இஸ் வாட் இஸ் ஹேப்பனிங். ஸோ அப்பெலட் ஒர்க்கு வரும்போது இந்த சிஸ்டத்தையே மாறினா ப்ராபப்ளி சம் ஆஃப் ஜட்ஜ்மெண்ட்ஸ் வில் பி மச் பெட்டர். இட் இஸ் ஈஸி ஃபார் அஸ் டு see that the clients what we serve the client will be looked at differently. Anyhow, சுமாராக ஏதோ பண்ணேன் அவ்வளோதான். Because I was not well for 3-4 days. So I told him I will come and do it today. அதனால வந்துட்டேன். இன்னொரு செஷன் வச்சுப்போம் இன்னொரு வாட்டி. இந்த வாட்டி ரொம்ப இதாக இருந்தது. அண்ட் some of them are prepared with my juniors. I have to thank them. சுருட்டு போடும்போது குரூப் ரோட் போடுறாங்களா நம்பரே ஆகாது இல்லைங்க. எல்லாமே they think it's speeding up the trial. It's not. கிடையவே கிடையாது. எனக்கு தெரிஞ்சு எதுவுமே அதெல்லாம் எல்லாம் பயத்தெல்லாம் இருக்கு. கரெக்டுப்பா, அதற்கு தெரியும். வாட் ஐம் சேயிங் இஸ் இது வாட் எவர் இட் இஸ் திஸ். ஆமா ஆமா தேவையே இல்லை, தேவையே கிடையாது. ரெஸ்டியூஷன் வரும்போது அதுல disputes arise sometimes. A determination is made, so that is considered to be a decree and you have file an appeal. That's also a decree. அதுக்காக சொன்னார் 144லயும் ஆர்டர் reads as a decree. Therefore an appeal will lie, not an order. It is a decree because a decision is made relating to the rights of parties. அதனால I think apart from what I spoke, in the judicial change ஆகிறதுக்கு ஏதாவது வழி பண்ணணும். Something related to the trial courts. இது மாதிரி examination of witness for years together, that should be avoided. நிறைய அது மாதிரி நிறைய நடக்குது. 9 வருஷம் 8 வருஷம் 4 வருஷம் 5 வருஷம்லாம் எவிடன்ஸ் எடுத்தா என்ன அர்த்தம்? And crimes sometimes they come from long distance, 40 kilometers, 50 kilometers வந்துட்டு போறாங்க. அவன் வரலைன்னா claim not available, ஒரு அர்ஜென்ட் ஆகிடுது. Something should be done on that. Anyway, ரொம்ப தேங்க்ஸ். பட் ஜூனியர்ஸ்க்கு என்ன ஹெல்ப் பண்ணணுமோ I'm prepared to give on this. Today my performance, I myself feel it's not go okay. Right.
Though senior is not well, he is prepared to his extent, and it's like only a preliminary degree. The next part will be in like a final degree. And senior was giving so much of advices like evidences in the first appeal, substantial of question of law in the first appeal and substantial question of law in the second appeal, reassessment evidence, so much things about the law in the civil to the juniors. One thing I think he has forgot to say is that in the court, I never seen him losing his temper. He will argue the case and leave the thing to the judge. So that attitude, I think.
Temper lose பண்ண பாயிண்ட் போயிடும்.
That is why I am coming to that. Because in the civil side, the other side will try to intimidate you or try to trouble you like Mohantan. And in that event, you should not lose the temper. And one more thing is, senior said about 17 or 27 LR petitions filed because one after one clients died. See, in the later vein, I would like to say, N.R. Chandran, former Advocate General, was arguing a case before Chief Justice Subhash Reddy, and he filed about 30 LR petitions. Subhash Reddy was, in fact, said, how come you have so much of LR petitions? N.R. Chandran தமிழ்லயே சொன்னாரு, 2 விஷயங்கள கிளைண்ட் செத்து போவாங்க. ஒன்னு நேச்சுரல் டெத், ரெண்டாவது நம்ம கேட்கிற ஃபீஸ்ல. சுபாஷ் ரெட்டிக்கு தமிழ் புரிஞ்சுது. With these few words, I give the mic to Sivasundaram for his vote of thanks. Sir. I request Additional Solicitor General A.R. Sundaresan, the former president, to give a shout to the senior T.R.Rajagopalan, former advocate. Memento.
பாட்டே சொன்னாங்க.
And now I request M.S. Subramaniam sir to give the memento.
சார் இந்த பக்கம் சார்.
Friends, I thank all the seniors and others for spending their time, and I thank the senior. Despite his health conditions, he said he will come. So when I called him on Monday, he said he is not well, but he said Thursday I will make it and I will make this presentation. And I thank him, and I thank all the members who have attended today. And on Monday, I think we have Tuesday we have another session. Monday we have another session. Monday, yes, Monday we have another session, and overview of criminal trial taken by Honorable Mr. Justice N. Satish Kumar. I request the juniors and others to come in large number. Thank you. It's open to all lawyers.